A fiery Congresswoman's blistering attack on Justice Amy Coney Barrett backfires spectacularly, as Barrett's razor-sharp response unveils a truth so stunning it shatters the narrative and redefines the Supreme Court's legacy. The Supreme Court chamber pulsed with raw tension, its marble walls and soaring ceilings amplifying the weight of a historic showdown. Justice Amy Coney Barrett stood poised at the bench, her black robe a stark contrast to the glaring lights that bathed the packed courtroom. At 52, Barrett was a beacon of calm, her piercing intellect and unflappable demeanor a fortress against the storm brewing before her. Across the room, Representative Jasmine Crockett, a 42-year-old Texas firebrand, had just unleashed a scorching indictment, her voice echoing with righteous fury. "Justice Barrett is dismantling decades of women's progress," she declared, her words a lightning bolt that electrified the chamber. The accusation, bold and unyielding, sent shockwaves through the audience, progressives nodding fervently, conservatives shifting uneasily, and cameras capturing every heartbeat of this explosive clash. Moments earlier, Crockett had strode to the microphone with the confidence of a seasoned trial lawyer, her eyes blazing with conviction. "Your ruling is an assault on women's rights and a betrayal of justice," she charged, her voice a clarion call that resonated with millions watching live. The room crackled, the air thick with anticipation as Crockett, buoyed by progressive acclaim and recent media triumphs, believed she'd cornered the conservative justice. Her team had armed her with a dossier they thought was ironclad, ready to expose Barrett's ruling as a dangerous betrayal. But Barrett, her notes neatly arranged, her legal mind a fortress of precision, didn't waver. What she pulled from her arsenal wasn't just a defense, it was a devastating counterstrike, a revelation so precise, so powerful, it left Crockett reeling, silenced the room, and sparked a national reckoning over truth, justice, and the very soul of the Supreme Court. This wasn't just a hearing, it was a seismic collision of ideals, a battle that would redefine how Americans perceive the judiciary. Before we plunge into this electrifying saga, smash that like button, drop your location in the comments, and subscribe for more gripping political analysis. Now, let's unravel how Amy Coney Barrett turned a fiery assault into a masterclass that changed everything. The stage was set for a confrontation that transcended politics, probing the heart of constitutional interpretation and the fragile thread of public trust. To grasp its magnitude, we must first explore the towering figures at its core. Barrett, the youngest Supreme Court justice, a scholar of unyielding principle, and Crockett, Congress's rising star, a warrior for justice with fire in her veins. Their clash wasn't merely personal, it was a battle of visions, a crucible for a nation divided. Amy Coney Barrett was no ordinary jurist. A former Notre Dame law professor, she'd ascended to the nation's highest court at 48, her appointment by President Obama a lightning rod for debate. A mother of 7, including 2 adopted children from Haiti, Barrett balanced family with a legal career marked by razor-sharp scholarship and an originalist philosophy rooted in the Constitution's sacred text. Her Catholic faith and measured demeanor made her a polarizing figure, adored by conservatives as a beacon of principle, vilified by liberals as a threat to hard-won progressive gains. Yet none could deny her intellect. Her ability to dissect complex legal questions with surgical precision, or her composure under the fiercest fire, a calm forged in the crucible of high-stakes judicial battles. Jasmine Crockett was her antithesis, a force of nature who'd stormed onto the national stage with the ferocity of a hurricane. A former civil rights attorney from Texas, she'd parlayed her legal acumen into a congressional seat, her powerful oratory and social media savvy making her a progressive icon. At 42, Crockett approached every issue like a courtroom showdown, her advocacy for voting rights and women's issues a relentless crusade against injustice. Her style, bold, direct, unapologetic, had earned her a legion of followers, her X posts and TV appearances amplifying her voice to millions. To her supporters, she was a fearless truth-teller, challenging the powerful with unyielding courage. To critics, her rhetoric sometimes veered into theatrical grandstanding, prioritizing impact over nuance. In this hearing, she saw a golden opportunity, not just to hold Barrett accountable, but to expose what she believed was a dangerous judicial overreach, a ruling that threatened the very fabric of women's rights in America. The stakes were nothing short of monumental, centered on Barrett's recent ruling in Women's Health Alliance versus Rogers, a case that had ignited a cultural and political firestorm. The decision appeared to narrow protections against workplace discrimination for women, sending progressive media outlets into a frenzy with headlines screaming headlines like "Barrett rolls back women's rights" and "Supreme Court betrays women." Conservative outlets rallied in defense, framing the ruling as a disciplined adherence to statutory text, a triumph of law over activism. The case wasn't just a legal dispute, it was a cultural flashpoint, its timing mere months before the midterm elections amplifying its seismic impact. The hearing room was a pressure cooker, every seat filled with journalists, activists, and politicians from both sides of the aisle. Cameras from every major network hummed, their lenses trained on the unfolding drama, ready to broadcast each moment to a nation hungry for clarity or outrage. The outcome could sway public opinion, shape electoral narratives, and redefine the Supreme Court's role in a nation teetering on the edge of division. As Crockett approached the microphone, adjusting it with a deliberate flick, her team passed her a thick stack of documents, their confidence palpable. They believed they'd armed her with an arsenal of evidence, legal briefs, expert statements, and Barrett's own writings, sufficient to dismantle the justice's credibility and expose her ruling as a betrayal of women. Barrett, meanwhile, sat serene, her notes meticulously arranged, her legal mind a fortress of preparation. She wasn't just ready to defend her ruling, she was poised to transform the narrative, to reveal a truth obscured by headlines and sound bites. The room fell silent as Crockett began, her voice ringing with authority, each word a carefully aimed dart. "Justice Barrett," she declared, her gaze locking onto the justice like a laser, "your ruling in Women's Health Alliance has gutted workplace protections that women have fought for and relied upon for decades. How do you justify this brazen abandonment of established precedent?" The accusation hung heavy in the air, the silence deafening as every eye turned to Barrett. The justice remained unruffled, her hands folded neatly, her voice steady, yet imbued with quiet strength. "Representative Crockett," she responded, "you've mischaracterized my opinion. The ruling doesn't dismantle protections. It applies the statute exactly as Congress wrote it." The retort was calm but unyielding, a signal that Barrett was not here to be steamrolled. Crockett, sensing an opening, seized a document from her stack, holding it aloft for the cameras, its pages a prop in her prosecutorial performance. "Justice Barrett," she said, her tone sharp, "I have here statements from 3 leading women's rights organizations calling your interpretation dangerous and regressive. These aren't political activists. They're legal experts with decades of experience." Murmurs rippled through the crowd, Democratic allies nodding vigorously, the tension in the room ratcheting higher as camera flashes illuminated the scene. Barrett's composure held firm, her expression betraying no hint of unease. "With respect, Representative," she replied, "those organizations represent a particular viewpoint. My duty is to the law itself, not to any advocacy position." The response was a deft parry, but Crockett was undeterred, her voice rising with a prosecutor's zeal. "So you're claiming these experts don't understand the law as well as you do?" she pressed, her words dripping with challenge. Barrett's tone remained even, but a hint of firmness crept in. "That's not what I said. Judicial interpretation must be grounded in the text of the law, not shaped by desired outcomes. The exchange was now a high-wire act, each word a spark in a powder keg, the audience hanging on every syllable. Crockett, sensing blood in the water, produced a thicker document, her movements deliberate, her voice triumphant. "Let me read your own words, Justice Barrett, from a 2017 article before your confirmation," she said, her tone laced with accusation. "Courts should exercise caution when interpreting statutes that affect vulnerable groups." Your words. Yet in Women's Health Alliance, you showed no such caution. How do you explain this contradiction? Camera flashes intensified, capturing Barrett's subtle shift as she reached for her own folder, a gesture that went unnoticed by Crockett, but not by the keen-eyed reporters in the press gallery. From the Republican side, Representative Jim Jordan leapt to his feet, his voice booming. "Madam Chair, this line of questioning is inappropriate." Crockett fired back without missing a beat, her voice slicing through the interruption. "I have the floor, Representative Jordan. Justice Barrett, how do you reconcile these contradictory positions?" Barrett took a measured breath, her eyes meeting Crockett's with unflinching resolve. "There's no contradiction, Representative," she said, her voice steady. "Context is critical. If you read the full paragraph from my 2017 article, I wrote that caution means fidelity to the law's text, not departing from it to achieve preferred outcomes." The response was a surgical strike, but Crockett, undaunted, flashed a faint smile, as if she'd anticipated this defense. "That's interesting," she countered, "because your ruling cites 3 cases that directly contradict your position in this case." The room stirred, legal reporters scribbling furiously, even some of Barrett's supporters tensing in their seats. The accusation landed like a grenade, the crowd buzzing with anticipation as Crockett drove her point home. "Am I misinterpreting, Justice Barrett, or is it more convenient to ignore these cases now? This is the problem. The Supreme Court cannot cherry-pick interpretations to suit a particular ideology." The chamber erupted, liberal supporters cheering, a voice in the back shouting, "That's right!" before security swiftly intervened. Conservative murmurs grew louder, the divide palpable as the hearing teetered on the edge of chaos. Barrett, unruffled, reached for her water glass, taking a deliberate sip, her calm a stark contrast to the storm around her. Then, with a subtle shift, she reached for a specific folder, her movements deliberate, her presence commanding. "Representative Crockett," she said, her voice resonating with a quiet authority that silenced the room, "I believe it's time we examine the complete record." The atmosphere shifted instantly, a hush falling over the crowd as Barrett's confidence caught Crockett off guard. This wasn't a retreat. It was the prelude to a reckoning. "You've made several claims about my ruling in Women's Health Alliance that require clarification," Barrett began, her tone calm but laced with an edge of steel. She lifted a document from her folder, its pages crisp and marked with precision. "This is the complete text of my opinion, not the selective quotations that have dominated certain media narratives." She turned to a highlighted passage, her voice clear and commanding, each word a hammer striking the anvil of truth. "Let me read what has been consistently omitted. Nothing in this ruling diminishes the protections afforded to women under Title VII or any other anti-discrimination statute. Rather, this decision clarifies that the procedural requirements established by Congress must be followed by all parties." The words reverberated, a thunderbolt that stunned the room into silence, journalists scribbling furiously as the weight of Barrett's revelations sank in. "The issue in Women's Health Alliance was not about reducing protections for women," Barrett continued, her gaze locked on Crockett, unyielding and direct. "It was about whether a plaintiff can ignore a statutory deadline of 173 days to file their claim." Gasps rippled through the audience, Crockett glancing at her notes, her confidence visibly shaken as Barrett pressed her advantage. The justice produced another document, her movements deliberate, her voice rising with conviction. This is the amicus brief submitted by the Women's Legal Defense Fund, an organization that often disagrees with my judicial philosophy. Even they acknowledged that the deadline issue presented a significant hurdle to the plaintiff's case. The revelation was a sledgehammer, exposing the gap between Crockett's narrative and the legal reality, Crockett's allies exchanging worried glances as their champion faltered. But Barrett was relentless, her voice now a blend of authority and moral clarity that filled the chamber. Furthermore, she said, pulling a third document, here's a fact that has been entirely absent from the public discourse. The plaintiff in this case has already refiled their claim through the proper channels, and that case is proceeding without hindrance. My ruling did not prevent them from seeking justice. It enforced the procedural framework established by law. The silence was profound, the room hanging on Barrett's every word as Crockett's attack unraveled. Barrett's preparation was a masterclass, her evidence a fortress that Crockett's accusations could not breach. The justice wasn't finished. She lifted an older document, its pages worn but potent, her voice now a clarion call for truth. Representative Crockett, you referenced my 2017 article. Let me read the full paragraph, not just the selective quote you cited. She paused, her eyes meeting Crockett's with unflinching intensity. Courts should exercise caution when interpreting statutes that affect vulnerable groups. This caution, however, must take the form of careful attention to the exact text and context of the law, not judicial rewriting to achieve preferred outcomes. Vulnerable groups deserve the protection of laws as written by their elected representatives, not the uncertainty of judicial improvisation. The words were a revelation, a testament to Barrett's unwavering philosophy, and they landed with devastating force. When you read the full passage, Barrett said, her gaze unwavering, it's clear that my ruling in Women's Health Alliance is entirely consistent with my principles. Crockett's composure crumbled, her hands fumbling through her papers as she searched for a counterargument, her earlier bravado replaced by uncertainty. "Justice Barrett," she stammered, "these procedural details weren't the focus of the media coverage." Barrett interrupted, her tone gentle but unyielding. "With respect, Representative, I am responsible for applying the law, not for how media outlets choose to characterize my rulings." The gallery buzzed with reaction, conservative supporters nodding vigorously, a murmur of, "That's exactly right," rippling through the crowd. Progressive journalists, caught off guard, exchanged stunned glances as Barrett's words reshaped the narrative in real time. Barrett's voice grew more commanding, her authority filling the chamber like a rising tide. "The Constitution requires judges to apply the law as written, not as we might wish it to be. When Congress establishes clear procedural requirements, neither plaintiffs nor courts can simply ignore them, no matter how sympathetic the case." She closed her notebook with deliberate care, her eyes sweeping to the cameras, addressing not just the room but a nation watching in rapt silence. The real story of Women's Health Alliance is not about rolling back women's rights. It's about respecting the rule of law and the proper roles of Congress and the courts. If the procedural requirements are too stringent, the solution lies with Congress to amend them, not with courts to rewrite them. Crockett, now visibly rattled, tried to salvage her position. "Justice Barrett, many legal scholars have criticized," but Barrett nodded, her response swift and measured. "And many have supported the ruling. Legal disagreement is normal and healthy. What's not helpful is mischaracterizing a procedural decision as a substantive attack on rights." The committee chair, sensing Crockett's struggle, attempted to intervene. "Perhaps we should move to the next question." But Barrett raised a hand, her voice firm yet serene. "If I may, there's one final point I'd like to address." She produced a single document, its significance palpable, her words carrying the weight of truth. "This is a letter from Sandra Martinez, the plaintiff in Women's Health Alliance, written last week. She writes, 'While I was initially disappointed by the Supreme Court's ruling, I now understand that my case is proceeding through the proper channels. Justice Barrett's ruling didn't deny my right to seek justice. It clarified the process I needed to follow. The room was utterly still. Crockett's planned assault in tatters, her notes useless against the fortress of Barrett's preparation. "Representative," Barrett concluded, her voice a blend of respect and resolve. "I deeply respect your advocacy for women's rights. I share that commitment. Where we differ is in our understanding of the judiciary's role in our constitutional system." The cameras captured the moment perfectly. Barrett, calm and authoritative, a pillar of judicial integrity. Crockett, rifling through her papers, searching for a response that would never come. What had begun as a progressive triumph had become a judicial masterclass. Barrett's clarity exposing the chasm between media narratives and the unvarnished truth of the law. The aftermath was a cultural and political earthquake, its tremors felt from Washington to every corner of the nation. Within minutes, clips of Barrett's methodical dismantling of Crockett's accusations spread like wildfire across social media, the hashtag #ChuckBarrettReceipts trending globally alongside "Read the Full Opinion" and "Context Matters." The video of Barrett reading the omitted passage from her ruling, holding the document aloft with quiet authority, amassed over 5 million views in mere hours, comment sections flooded with reactions ranging from awe to outrage. Conservative outlets seized the moment, replaying Barrett's most devastating lines, while even progressive legal analysts were forced to concede the point. CNN's Jeffrey Toobin, visibly chastened, admitted on air, "What we witnessed was a fundamental mischaracterization of Barrett's ruling corrected in real time. The procedural nature of the decision was largely overlooked, including, I must confess, in some of our own reporting." Behind him, a chyron read, "Barrett ruling, what media got wrong." Fox News' Andrew Napolitano was effusive, declaring, "Justice Barrett delivered a masterclass in judicial restraint and constitutional interpretation. This wasn't about politics, it was about the sacred role of courts versus legislatures." Sean Hannity opened his show with a bold headline, "Barrett exposes media manipulation of court rulings." By evening, the misleading headlines that had defined initial coverage were being quietly updated or replaced. The Washington Post published a sober analysis. Barrett's Women's Health Alliance, ruling, procedure, not substance. MSNBC aired a panel discussion on the importance of reading full opinions. The New York Times issued an editorial urging greater care in Supreme Court reporting, a tacit acknowledgement of the media's misstep. Crockett, reeling from the public backlash, issued a carefully worded statement. My questioning of Justice Barrett reflected the concerns of many Americans about women's rights. While we may continue to disagree on judicial philosophy, I appreciate her thorough explanation of her reasoning. Behind closed doors, the fallout was less measured. Sources reported that Crockett's staff faced an internal reckoning, with several aides at risk of reassignment. A viral clip, captured by a bystander's phone at a dinner event that evening, showed Crockett muttering to a colleague, "I was handed incomplete research. Someone's getting fired tomorrow." The comment, amplified across X, added to her challenging day, her once unassailable image as a progressive titan now tinged with vulnerability. The White House, caught off guard, treaded carefully. The press secretary, when pressed on the administration's stance, offered a neutral response. "We respect the independence of the judiciary and the importance of understanding court rulings in their full context." When asked if the president stood by earlier criticisms of Barrett's ruling, she deflected, saying only, "We're reviewing the full opinion." The exchange's impact rippled far beyond politics, reshaping legal education and public discourse. Law professors nationwide downloaded the complete Women's Health Alliance opinion for classroom use, its procedural nuances a case study in statutory interpretation. The American Bar Association announced a new initiative to improve public understanding of judicial decisions, citing the hearing as a catalyst. Barrett's public image underwent a dramatic transformation. Once caricatured as a conservative ideologue, she emerged as a meticulous jurist, her commitment to principle transcending partisan divides. People magazine's feature, Amy Coney Barrett, the Justice Who Surprised America, captured her in her robes, a symbol of judicial integrity. Public trust in media coverage of the courts took a measurable hit. A Gallup Snap poll conducted 2 days post-hearing revealed that 64% of Americans felt major news outlets had failed to accurately represent Barrett's ruling, with trust in judicial reporting dropping 12 points overnight. In response, newsrooms scrambled to adapt. The Associated Press updated its style guide to mandate procedural context in court reporting. CNN pledged to read full opinions before publishing, eschewing reliance on advocacy group reactions. Law schools reported a surge in applications for courses on judicial writing, with Georgetown Law launching a new class, beyond the headline, Understanding Supreme Court Opinions. Student interest in clerkships with Barrett reportedly doubled, a testament to her newfound stature. Sandra Martinez, the plaintiff in Women's Health Alliance, gave a poignant 60 Minutes interview a week later, her words cutting through the noise. "I was devastated at first," she said, her voice steady. "But my lawyers explained it wasn't a rejection of my claims, just how they were filed. My case is moving forward, and I'm grateful for the clarity." The interview, offering a human perspective on the ruling, drew the program's highest ratings in 3 years, underscoring the public's hunger for truth over sensationalism. Women's rights organizations, initially vociferous, issued more measured statements. The Women's Legal Defense Fund noted, "While we have concerns about Justice Barrett's broader jurisprudence, we recognize this ruling was primarily procedural." The National Women's Law Center launched an initiative to educate journalists on the technical nuances of court decisions. The Barrett-Crockett clash became a touchstone in legal and journalism ethics, its lessons reverberating through academia and media. Law schools incorporated the hearing video into courses on legal ethics and public communication. Journalism programs added it to curricula on reporting complex subjects. Social media platforms noted a shift in user behavior, with X reporting a 43% spike in users sharing links to full court opinions, and Google searches for "how to read Supreme Court opinions" surging by 400%. For everyday Americans, the confrontation offered a rare glimpse into the Supreme Court's true work, not as a political battlefield, but as an institution wrestling with the intricate interplay of law and justice. Civics teachers nationwide used the video to teach students the difference between procedural and substantive legal questions, sparking a renewed interest in constitutional literacy. A month after the hearing, a bipartisan group of senators introduced the Judicial Transparency Act, aimed at making Supreme Court opinions more accessible to the public. The bill's sponsors cited the Barrett-Crockett exchange as inspiration, a call to bridge the gap between judicial reality and public perception. Barrett herself remained above the fray, maintaining the traditional judicial distance from political controversy. But in a speech to the American Law Institute weeks later, she offered a subtle reflection. The judiciary's legitimacy depends on public understanding of what we actually decide, not what we are reported to have decided. The words, understated yet profound, encapsulated the lesson of the confrontation, a plea for truth in an age of instant outrage. The real triumph wasn't Barrett's victory or Crockett's defeat. It was the awakening it sparked. In a polarized era, the exchange proved that clarity could cut through division, that truth could prevail over sound bites. It challenged Americans to look beyond headlines, to read the fine print, to engage with the law as citizens, not spectators. As one viral X post put it, No matter your politics, today reminded us the law is complex, and we all win when we slow down and read. The Barrett-Crockett saga didn't just clarify a single ruling, it ignited a movement, urging a nation to seek truth, demand accountability, and honor the Constitution's enduring promise. If this saga of truth and conviction set your heart ablaze, smash that like button, subscribe, and comment below. How can we ensure media covers the courts with integrity? Share stories of moments when truth triumphed in your world. Join us for more battles shaping our nation, and let's fight for a future where justice and clarity reign supreme.